Welcome to SQE1 Preparation, Criminal Practice, Client Options in Police Interviews, and the Safest Option by Street Lawyer, helping SQE1 students pass first time and also educating those who are curious about the criminal law and criminal practice, especially in the police station. So what key knowledge is covered in this class? Well, this class covers an overview of client interview options, providing a comprehensive understanding of the various choices available during the client interview. I'm going to be focusing on the advantages and disadvantages of each choice, helping you understand the implications of different interview strategies. You're going to learn about what a solicitor would likely advise in an effective strategy to protect and advance their client's interests based on professional experience and legal considerations. And the class covers case law and legal implications with a focus on the Criminal Justice and Public Order Act 1994, providing a crucial context for interview strategies. And there's a specific issue that's going to be looked at, which is about adverse inference. By way of an SBAQ tips, this could centre on the best option for the client during the police interview, whether any adverse inference can be drawn from the option chosen. And this class should be watched in conjunction with another class which is on no comment and adverse inference. There's 5 test your knowledge questions on this slide based on a true or false answer. Is question 1 true or false? Selective silence cannot result in adverse inference. Question 2, true or false? A prepared statement allows the client to avoid answering questions directly. Question 3, true or false? Police are obligated to disclose all the evidence before questioning begins. Question 4, true or false? Remaining silent can always prevent self-incrimination. And question 5, true or false? Answering all questions may bolster a client's credibility if later they rely on a defence. And then there's test your knowledge 2. Tony's arrested for common assault. During the police interview, he gives no comment to all the questions because based on previous experience, he believed the police twist answers for their own benefit. Tony's charged with common assault and given a court date. He attends court and speaks to his solicitor. Tony tells the solicitor he acted in self-defense. The solicitor advises Tony over the adverse inference. Which of the following best describes the advice that the solicitor will give Tony about adverse inferences? 1. If Tony gives evidence at trial and states that he acted in self-defense, which he relies on as his defense, the court may draw inferences of guilt from Tony's refusal to answer police questions. Or is the best answer 2. If Tony gives evidence at trial and states that he acted in self-defense, which he relies on as his defense, the court may draw any inference that may appear proper from Tony's refusal to answer police questions. As always, the test your knowledge answers are at the end of the class, but let's look at the content first of all. Question: what is a suspect's right to silence? A suspect has a right to remain silent during police interviews under caution. Under Section 34 of the Criminal Justice and Public Order Act 1994, silence may lead the court to draw any inference that may appear proper from a suspect's refusal to answer police questions if they rely on facts not mentioned during the police interview, including drawing an adverse inference at trial if the suspect later relies on facts not mentioned during the police interview. And the relevant case there is Condron versus UK 2001. Question: what is an adverse inference? Well, an adverse inference is a negative conclusion that the court may draw about the defendant's silence during questioning. For example, the court might infer that the defendant remained silent during that police interview because they had no credible explanation at the time, and their subsequent defence at trial is a recent fabrication. And you've got the case law of R versus Cohen and R versus Beckles if you want to check those cases out. So question then is what are the client's 4 options during a police interview? Well, there are 4 options of these, generally speaking. 1, answer all the questions. The client can choose to answer all the questions asked by the police under caution. 2, the client can remain silent. The client has the option to remain completely silent during police questions. the common way that this is phrased is by when the client says no comment to the police questions. 3, selective silence. The client can choose to answer some questions while remaining silent on other questions. And then 4, provide a prepared written statement. The client can opt to provide a prepared written statement in response to police questioning and then proceed to go no comment. What are the advantages and disadvantages of answering all questions? And this is for the not guilty client. So if you have a client who has given not guilty instructions during the private consultation, what are the advantages and disadvantages of answering all those questions that are going to be put to the client by the police? There's a couple of advantages and disadvantages. So let's just go through the advantages. Advantages are: establishes an early defence on record, supporting credibility, may prevent adverse inference if defence aligns with interview answers, and potentially the case might get dismissed if the police accept the defence, e.g. if the client was acting in self-defence or has an alibi. So it can be the suspect client might receive a no further action at the police station, so the matter doesn't proceed any further. And then you have disadvantages. One disadvantage is that if the client does answer questions, there's a risk that they may self-incriminate themselves or confess under pressure. Vulnerability to being tripped up by the police may reveal undisclosed evidence that the police may not have. And reference should be made to the CJPOA 1994 section 34. Question: what are the advantages and disadvantages of answering all questions if the client is guilty, if the client's given guilty instructions during the private consultation? What are the advantages and disadvantages of answering all the police questions in that situation and circumstances? Well, the advantages of answering questions is it aids in potentially receiving a police caution rather than being charged if it's a first offence, and a little bit more detail, it's a low level offence and the client accepts and regrets the offending behaviour. The second advantage is it supports a plea mitigation by showing cooperation, potentially reducing a sentence. So they're the two main advantages for a guilty client to answer police questions. Then you've got disadvantages. It may increase the risk of self-incrimination. It may strengthen the case against the client if the police use the admission, and this is basically where you have a weaker case, and the client may answer questions, and it may in effect result in self-incrimination and strengthening the case against them. So now we turn to what are the advantages and disadvantages of remaining silent, and this is for a not guilty client. So the client's given not guilty instructions to their solicitor prior to the police interview. And remember, remaining silent often it occurs in practice where a client would say in the police interview to all the police questions, no comment, or they could just remain completely silent. But the advantages are, for a not guilty client to remain silent, it prevents self-incrimination and possible trap questions by the police if they haven't disclosed something to the solicitor prior to the interview and they disclose that during the interview. And it might hinder the police case if its weak evidence exists. So by answering questions, you might actually strengthen the case. So the disadvantages are potential for adverse inferences under CJPOA 1994. We focus here on this class of section 34 and the next class about no comment and adverse inferences. And if the case does proceed to court, it may appear to the court as a tactic to fabricate a defence later mentioned either in the defence case statement or when the defendant gives evidence in court. So there are potential for adverse inferences, and it may also appear to the jury or to the judge, whoever the arbiter of facts are, that the client is fabricating their defence. So the question then is what are the advantages and disadvantages of remaining silent? This is for the guilty client who admits committing the offence to his solicitor prior to the police interview. The advantages are avoids adding more incriminating evidence to the police case, and the disadvantages are it has limited impact on sentencing, since the alternative, which is cooperation, may support mitigation, and it reduces the chance of receiving a police caution or to receive a lesser charge. So the question then is when should a solicitor advise a client to give a no comment interview? Well, there are a couple of factors the solicitor takes into account, and they're mentioned here, and they're outlined as lack of disclosure, police withholding information, there's concern over tactical ambush by the police, disclosing information during the police interview not previously disclosed to the solicitor prior to the police interview, weak evidence, police may not have enough evidence to charge, client vulnerability, age, mental state, intoxication or stress, therefore the client suggestible to making false admissions, complexity, case with complexity or is historic may justify silence as the client is unable to recall the events. And then there's maybe some personal reasons, for example an affair or an alibi that could cause personal harm if disclosed to the police. And there's a case there, R versus Howell, that you can check, highlights risks of adverse inferences with selective silence. And then the question then is what are the advantages and disadvantages of selective silence? Is selective silence ever a good strategy? Advantages are allows partial defense while avoiding harmful admissions, allows a client to admit a less serious offence whilst remaining silent on a more serious offence, with the hope the police will charge the client with the less serious offence, and NFA on the more serious offence. And there's an example of possession of drugs versus possession with intent to supply. Client would admit to possession of drugs, which is a lesser offence, and go no comment on possession with intent to supply, with the hope that the client will receive a charge or a caution for a possession of drugs rather than possession with intent to supply. And then there's disadvantages of selective silence. There's still the issue of adverse inferences. If a person then raises a defence at court, and then there's also the other issue, which is that the client, through the selective silence, answering some questions and not answering other questions, might be seen as hiding information. And the case of R versus Knight is particularly an interesting case to read. And then we have the question of what are the advantages and disadvantages of a prepared statement? Should a client make a prepared statement? This is a prepared statement which is served on the police or kept on file, and the client would go no comment during the police interview. Well, the advantages of a prepared statement is controlled. It allows the client's defence to put on record without risk of making any admissions. As a consequence, it avoids adverse inferences, CJPOA 1994. There are disadvantages. It may be seen as controlling the narrative. Police can still challenge the statement. And there's a risk if the evidence that the police later obtain or have contradicts the actual statement. If there is going to be a statement, well, what should be the content of a written statement? Well, it could, what should be included in a written statement for a client who raises a defence? Well, it needs to be clear facts supporting defence, and it needs to say make points which avoid unnecessary admissions. And the strategic point there is it might help prevent possible adverse inferences under the CJPOA and under sections 36 and 37. Which we're going to look at in later class. And then there's a question about timing. When should a prepared statement be served? When should a prepared statement be handed to the police? During the police interview is one option, and that could be at the beginning or the end of the police interview. After the interview has concluded or on charge, or retained on the solicitor's file until necessary. And there's the strategic point there is the delay exists if the police evidence seems weak to avoid strengthening their case. And then finally, going back to these test your knowledge questions, true or false, you can see the slide there, and then you can pause it, check whether you know the answers, and then look at this slide here. These are the answers, questions 1 to 5. Pause the slide, check your answer, and then look at this slide. This is the next final test your knowledge question, which is question 2. pause the slide, read the description of the question, and then look at the two options and check your answer. Finally, remember, watch all the videos in the SQE Prep Criminal Practice Series. Understand the functioning and legal knowledge being examined by reading the SRA website for yourself. Revise from a really good SQE book or books. Attend and participate in class. Prepare those Q&A flashcards. Practice as many SBAQs as possible. Subscribe to Community Legal Education. Put your notification on so you don't miss out. Hope you found this class useful. See you in the next class. Thank you for watching.